Right to. Harrington here, folks. Now, last 3 weeks, we've been talking about litigation. Fight. All right, so we understand that is important. It's just a part of business reality. I've heard some stories about people who say, I've been doing this for 20 years. I've never had a lawsuit. I don't know if that's true or not. Maybe my perspective is warped, but you and I know that that's important information. Okay, but now you've eaten your spinach, your cauliflower, your Brussels, your Brussels sprouts. So it's time to talk about more uplifting things, and I promised you more uplifting things. So what have I come up with? All right, trademarks. That's what I've come up with. And you're thinking, oh, what's so uplifting about that? Well, okay, so it's one of two things. Either you have come up with this cool-ass design, and you're hoping to put a successful company with it, or you already have a successful company, and now you have a brand that's worth protecting. So see, positive. So let's get it. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. So what is a trademark? Okay, well, it's intellectual property. And when we're talking about intellectual property, we're usually thinking of either patents, trademarks, or copyrights. So let's start with what trademarks are not. A trademark is not a patent. Those are usually technology or pharmaceuticals. I mean, it's the actual invention. That's what you get a patent for. It's not that. Trademarks are also not copyrights. Copyrights are for protecting artistic works like a song or a book or maybe a screenplay, things like that are what we normally think of when we're copyrights. A trademark, as the name implies, is a mark. And what we mean by that is it's like a logo, or it's a piece of artwork is really the best way to describe it. But let me give you some examples. Kind of a design that would be, a symbol. So I think people understand that a trademark can be a logo, right? That's clear enough. But I think where people sometimes get confused is, how does the name of the company fit into that? All right, well, let's take my law firm, for example. See that? So Harrington Legal Alliance, but it's just the name of the firm, but look how stylized it is, right? The Harrington's in green, a very particular shade of green. The Legal Alliance is in white and in lowercase. I mean, it's if you do it this way, it's just the name of the firm, but it's so stylized that it actually becomes a piece of art, all right? Same thing with famous companies like Coca-Cola. There's another good example. It's just the name of the company, Coca-Cola, but it's got that red background, the white letters. It's got a very swooshy style to it. And then, of course, if you want to think about the more typical examples are like Apple. They have that silhouette of an apple with a bite out of it. Or Lacoste has its alligator. My dad had a pest control company, and his mark was a roach. Very impacting. Part 2. Now, you can protect and register your trademark on a state level or a federal level. What are the differences? Which one would I recommend? Well, spoiler alert, I'd say go federal every chance you can. But what are the differences? Well, to register your trademark at the federal level with the USPTO, United States Patent and Trademark Office, you're supposed to use your trademark in interstate commerce. And if you are just a local business, you don't have branches all over the country or in different states or whatever, then the alternative might be that you register the trademark at the state level. Now, I'm going to try to steer you away from registering your mark on the state level because, well, for one thing, it's not much cheaper. It might be a little bit, but it's pretty close to the same cost as doing it at the federal level. So why have protection just at the state level when you can protect your mark in the whole country? But you might be thinking, Jeff, you just told me that if I am just a local business and I don't have offices in other states, then I can't register. I don't qualify to register on the federal level. You know what, though? It's not that hard to qualify for federal registration as you might think. For example, maybe you are just a local business, but do you service or provide goods to people in other states? Do you have customers or clients who are in other states? Or how about this? Do people in other states or in other countries access your website? And even if your answer to both of those questions is no, well, how about this? Is there a chance? Do you contemplate? Is there some intent of potentially having offices in other states or servicing and or providing goods for clients and customers who are in other states? If you even have the intent, that would probably qualify you to register at the federal level. Part 3, the registration process. Okay, so let's get into it a little bit. First step is a clearance search. So you're going to run a search. We don't do this in-house. You usually use a third-party company to do this. Run a search on all the different marks and names of companies out there in the United States that might be considered confusingly similar to your mark. So at the end of the clearance search, you're going to get a report, and you're going to be able to go through that with your attorney probably to see if there are other marks that compete with yours that are in the same class as yours. We're going to get to that. That could be considered confusingly similar to what it is you want to register as your trademark. If you get through the clearance search and you feel like you have something that's unique enough that is not likely to be challenged by a competitor, then you're going to get together your specimen, which means it's the mark as you have used it in commerce. So maybe your mark as it appears on your website or on your products or on any of your marketing materials. That's going to be your specimen. Get that ready to submit. You're going to have to think about what classifications you want to cover. Now, there are lots of them, and you have to pay for each and every class that you want to protect. Usually there's going to be like 2 or 3 different classifications that you're going to want to cover. I'm trying to think of an example to help you understand the classes, because they're kind of nuanced and there tend to be several, and you're going to want to know which ones to cover and which ones you're okay not covering. You have to pay for each and every one of them. So here's an example for you. We recently filed a registration for a trademark for our church. So obviously there's going to be a class that's for religious institutions, but then there's going to be very similar and related classes for like ministries or outreach programs or missionary activities. You see what I mean? They're going to be very closely related classes, and you'll want to probably cover each and every one that seems to be closely related to what you do. All right, once you get your application together, you got your specimen, you got all your classifications worked out, you submit that as an online process, and then you're going to be assigned an examining officer. Examining officers that I've dealt with, I mean, look, ideally you won't be dealing with one that your application is so perfect that it'll just go through and you don't have to talk to anybody. However, on those occasions when I have needed to talk to an examining officer, they've been easy to work with. They give the impression anyway that they're actually trying to help you. Now, what we're trying to avoid, but which does come up very often and is not the end of the world, is something called an office action. And that is a communication from your examining officer asking for more information or asking you to clarify something or asking you to do something on your application. Now, if you do get an office action, hopefully it's something simple that you can fix with minimal effort, but it could get somewhat contentious. What I mean to say by that is perhaps the officer is leaning towards this is not trademarkable. And you may have to go back and forth to convince him or her that, you fit the statutory requirements. All right, last step of the process essentially is publication. So you get through the officer, convince him or her, if you got an office action, that you're good to go. So then they will then publish your trademark to the public and give your competitors a chance to challenge. That brings us back to the beginning. This is why we do the clearance search right from the start, because you're hoping not to get challenged by any of your competitors. Now, I can tell you that some of these companies, these big ones, they're crazy. They don't play around. I'll throw a couple names out there for you. Invisalign, or I had a client who sold wines, and it was under the label Green Griffin, I think, or something like that. They got challenged as well. Let me just say that some of these companies take their intellectual property very seriously, and so when you publish your mark, they may very well come out of the woodwork. They're not going to be shy. If they feel like there's any chance that your mark could be confusingly similar or in any way affect their business, they take it as though you are grifting off of their hard work, and they will not have it. And look, to be fair, I mean, you can understand that, right? It takes years and tons of money to build up a reputation, to come up with a recognizable brand. You're going to have somebody come up with a name that's really similar to yours, or even colors and design that are very similar to yours that are going to confuse the public. And you're going to have the benefit then of all the work they put into building their brand. So if during this publication phase there is a challenge to your mark, well, it's going to be expensive because it's going to have to go to federal court, or you're going to have to back down. Those are your two choices. You can either litigate possible infringement in federal court, or you can abandon your application. So again, you can understand why we try to do a good job with that clearance search so we can avoid that scenario. Okay, but let's say that you get through the publication, you don't get challenged, you don't end up in federal court fighting over infringement. Then your mark will be registered, you'll get a number for that, and you're protected. You can then do the same thing to anybody else who tries to infringe upon your intellectual property. Just one final thought. So now your mark is registered with the USPTO. So just how far does that extend? It extends to the 50 states and US territories, but that's it. It does not provide you any kind of international protection. But I don't want to go too much further because I'll soon get out of my depth here. Let me just say this. You will need to register your mark separately in Mexico and in Canada. As for South America, I think you'll probably have to register in each and every one of those countries. Europe, there's an exception. There is a way to cover all of Europe together, and there are pros and cons to doing that. So don't make any decision based on this video. Consult with an attorney, in particular a IP attorney. So that's trademarks, guys. Listen, if you've got a successful company, then you're probably going to want to protect the brand. You should. Or if you come up with a cool design, you probably want to protect that as well. There's a bit of a process to it. You may need an attorney to get through it, but look, it's not terribly expensive. It's worthwhile. Como siempre, recuerda que hablamos español. As for the likes and the comments and all that, do the honorable thing, please. And I will be back with more for you next week. Later on.